Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this content, please remember to subscribe. For today's content, we conclude with Fisher 2 versus University of Texas. In this case, after being sent back to the Court of Appeals, because the Court of Appeals screwed up the legal standard, the Court of Appeals applied the right legal standard the second time around and actually looked at what the University of Texas was doing and whether or not it was, in fact, narrowly tailored to pass strict scrutiny. So in this case, the United States Supreme Court has to decide whether, having done that, the Court of Appeals actually arrives at the right conclusion and whether or not the University of Texas is, in fact, applying strict scrutiny for its racial practices at its university. Let's get started with this. The Texas legislature enacted HB 588, commonly known as the Top 10% Law. As its name suggests, the Top 10% Law guarantees college admission to students who graduate from a Texas high school in the top 10% of the class. Those students may choose to attend any public university in the state. So that's a pretty interesting policy from Texas. It says if you graduate in the top 10% of your high school class, we will guarantee you admission to any public university of our choice, which makes perfect logical sense. You've shown yourself to be academically successful, and so we'll guarantee you admission. Fair enough. The university used this admission system until 2003, when it decided the companion case of Grutter. In Grutter, however, the court upheld the Michigan law system of a holistic review, a system that did not mechanically assign points, but rather treated race as a relevant feature within the broader context of the university. So the University of Texas at Austin did not have any sort of racial discrimination or affirmative action program. But then, in a separate case, Grutter, the Supreme Court upheld the Michigan law school system as it applied to their system because it wasn't a quota, it wasn't a simple mechanical function, it was a more complex analysis. And so then the University of Texas picked a system that sort of mirrored that or came upon that. But of course, Texas has some differences, most notably this 10% law, which Michigan didn't have. So that is at least one major factual difference. Although the university's new admission policy was a direct result of Grutter, it is not identical to the policy the court approved in this case. Instead, consistent with the state legislative directive, the university continues to fill a significant majority of its class through the top 10% plan. In the law as it exists today, up to 75% of the places in the freshman class are filled through that plan. As a practical matter, this 75% cap, which now has been fixed by statute, means that while the plan continues to be referenced as top 10%, a student needs actually to finish in top 7 or 8% of his or her class to be admitted to this category. Now, when they say that, I think they mean at the University of Texas, Austin specifically, not in general. So if you graduate in the top 10% of your class, you're guaranteed admission to any university. But of course, some universities are bigger than others, and even the biggest universities only have so many spaces. So the legislature capped it at 75% of the class to make it a little bit easier on the university. So as a practical matter, you might need to be above 10% if you are applying to the most competitive schools within the University of Texas. So we'll admit you somewhere, but you might not necessarily get your first choice if other people want demanding. So that's what the legislature did, capped it at 75%. And the other 25% is open to admissions beyond that, which presumably would include foreign students, students from other states, and things beyond that so that the university could be more flushed out with those kinds of people as well. The university did adopt an approach similar to the one in Grutter for the remaining 25% or so of the incoming class, the ones that were not subject to this guaranteed admission plan. And in that 25% category, it included a personal achievement score. The personal achievement score included evaluation of the applicant's potential contributions to the university student body based on applicants' leadership experience, extracurricular activities, awards and honors, community services, and other special circumstances, including the person's own race. Once the essay and full file readers have calculated each applicant's AI and personal scores, the admissions officer from each school within the university set a cutoff score combination for admission and then admit all applicants who are above the cutoff point. In setting the cutoff, those admission officers only know how many applicants receive a given score combination. They don't know the factors that went into the score. The admissions officers who make the final determination as whether to admit a student will be admitted do not do so based on that race because they don't know it. It was only part of the score. They don't know what factors went into it, including race. So while race does enter the admission process, it enters it at only one stage, the calculation of the score, to which the admission officer doesn't have that particular component. Thus, although admissions officer can consider race as a positive feature of a minority application, there is no dispute that race in this context is but a factor of a factor of a factor. So it is buried relatively deep in the admissions decision. and therefore is only part of a holistic review calculus. Furthermore, consideration of race is contextual and does not operate as a mechanical plus factor for underrepresented minorities. The petitioner, Fisher, applied for admission to the university's 2008 freshman class. She was not admitted in the top 10% of her high school class, so she was evaluated through this holistic review, and her application was rejected. The petitioner then filed suit alleging the university's consideration of race as part of a holistic review process disadvantaged her and other Caucasian applicants in violation of the Equal Protection Clause. Fisher 1 set forth 3 controlling principles relevant to the assessing of the constitutionality of a public university's affirmative action program. Because racial characteristics so seldomly provide a relevant basis for disparate treatment, race may not be considered by a university unless the admissions program can withstand strict scrutiny. Strict scrutiny requires a university to demonstrate with clarity its purpose or interest is both constitutionally permissive and substantial, and the use of classification is itself necessary to accomplish this purpose. So we have to have both the compelling interest and it narrowly tailored to that interest. That's the two sides of strict scrutiny. So to have strict scrutiny, you need a compelling interest that is and narrowly tailored to that interest. So on the first half of that equation, compelling interest, you have to state its purpose or intent is permissible and substantial, which is another way of saying it's sufficient to meet the threshold, and also on the other end, that the means are narrowly tailored to that end. A university cannot impose a fixed quota or otherwise define diversity as some specified percentage of a particular group merely because of race or ethnic origin. Once, however, a university gives a reasoned, principled explanation for its decision, deference must be given to the university's conclusions based on experience and expertise that a diverse student body would serve to achieve educational goals. Though narrow tailoring does not require exhaustion of every conceivable race-neutral alternative or require a university to choose between maintaining a reputation for excellence and fulfilling a commitment to provide educational opportunities for all members of all racial groups, it does impose on the university the ultimate burden of demonstrating that race-neutral alternatives are both available and workable that don't suffice. So they have to show that this is basically the only way of achieving their goal. In seeking to reverse the judgment of the Court of Appeals, the petitioner makes 4 arguments. First, she argues the university has not articulated its compelling interest with sufficient clarity. According to the petitioner, the university must set forth more precisely the level of minority enrollment that it would consider to be a critical mass. Without a critical sense of what the university's goal is, the petitioner argues, a reviewing court cannot assess whether the university's admission program is narrowly tailored to that goal. As the court's cases have made clear, however, compelling interest that justifies consideration of race is not an interest in enrolling a certain number of students. So it's not about the number. So asking, what is the minimum number is asking the wrong question, at least according to the Supreme Court. On the other hand, asserting an interest in the educational benefits of diversity at large is insufficient. A university's goals cannot be illusory or amorphous. They must be sufficiently measurable to permit judicial scrutiny of the policies that are applied to achieve those particular aims. It needs to be tailored to the purpose. The university has provided, in addition, a reasoned principled explanation for its decision to pursue these goals. The university's 39-page proposal was written following a year-long study, which concluded the use of race-neutral policies and programs had not been successful in providing an educational setting that fosters cross-racial understanding, providing enlightening discussions and learning, or preparing students to function in an increasingly diverse workforce and society. The record contains significant evidence, both statistical and anecdotal, in support of the university's position. To start, the demographic data of the university has submitted shows consistent stagnation in terms of percentages of minority students from 1996 to 2002. For example, in 1996, the African American percentage was 4.1%, which was exactly the same in 2003. So they're saying that all their efforts have been unsuccessful to move the class to be any more diverse, which apparently would mean to be any more African American, at least in this context. Petitioner's final argument is that there's numerous other available race-neutral means of achieving the university's interest. A review of the record reveals, however, that at the time of the petitioner's application, none of the proposed alternatives was a workable means for the university to obtain the benefits of the diversity that it sought. So the university is saying it tried other things to achieve its ends, and none of them worked. For example, petitioner suggests the university could increase its outreach efforts to African American and Hispanic applicants. But the university submitted extensive evidence of the many ways in which it already intensified its outreach efforts to those students. The university created 3 new scholarship programs, opened new regional admission centers, increased its recruitment budget by $500,000, and organized 1,000 different recruitment events. Perhaps more significantly, in the wake of the prior case, the university spent 7 years attempting to achieve its compelling interest using race-neutral, holistic reviews, which apparently didn't work. None of these efforts succeeded, and the petitioner fails to offer any meaningful way in which the university could have improved upon them at the time of their application. These are but examples of the general problem. Class rank is a single metric, and like any single metric, it will caption certain types of people and miss others. This does not imply that students admitted through holistic review are necessarily more capable or more desirable of those admitted through the top 10% program. It merely reflects the fact that privileging one characteristic above all others does not lead to a diverse student body. Indeed, to compel universities to admit students based on class rank alone is in deep tension with the goal of educational diversity, as this court case has defined it. So while you could do strictly meritocracy, and maybe that might be a good idea for some universities, other universities don't want that, and you shouldn't force them to, or at least the Supreme Court seems to think that. A university is in large part defined by those intangible qualities which are incapable of objective measurement, but which make for greatness. Go to Clemson University would be my recommendation here. The court's affirmance of the university's admission policy today does not necessarily mean the university may rely on the same policy without refinement. It's the university's ongoing obligation to engage in consistent deliberation and continuing reflection regarding its admissions policies. Thus, that brings us to the end of the story of Fisher versus University of Texas at Austin. So under the case law as it exists right now, and this may change because the Students for Fair Admissions in their case against Harvard are certainly seeking to change it, but as it exists right now, a public university may use race as a part of an overall review. They can't do it as a mechanical factor, so it can't just be plus so many points. It can't be as a quota, it can't be a certain minimum, but it can be part of a factor to which, as part of an overall holistic equation, it's something they can consider. So the degree to which that is or is not being done, well, that's for courts to be able to look at in detail. But at least in the broad, this is something that's allowed for. So the Students for Fair Admission want to try to change this and take it away from being a valid factor. Some states do not allow for it to be a valid factor, perhaps most notably California, which has excluded it as a matter of its state constitutional law, much to the chagrin of its own legislatures, but they have, because they tried to undo that in the ballot and they weren't able to succeed. But it is an option that remains available. So it is a factor that a university can consider among many, and at least for a moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.